All right, go ahead.
Okay. Well, first of all, hello to everyone out there listening. Um, I'm good to let you know some of the laws and the corruptness in Tennessee. Let's just go out by starting just to talk about some several cases in which I've seen and looked over that a lot of these guys are wrongfully incarcerated down here. Um, like, for instance, the state and district attorneys, the reason why a lot of these guys are falsely incarcerated because they fail to investigate and seek true justice. Well, everyone should know that they all take an oath to support and defend the Constitution and to seek justice, not just conviction. But here in Tennessee, all they seek, it seems like, is convictions and not true justice. Let me explain to y'all what I mean. So, in several of these cases, I've noticed like juvenile courts will sit there and even give custody of children to those who are locked up to grandparents, and even though the grandparents have sexual abuse charges on them in the past. Um, that's one issue. Several issues. Another one is DCS is teaching children down here for 32 years, along with their constituents like Nashville Children's Alliance and others, to teach children to lie on individuals where they never knew anything about anything. For instance, where's this one guy's case? I don't want to get in the name of it in Sullivan County, Tennessee, though. That sits there, and the man's been down several years for allegations against him that were lies. And come to find out, he recently got evidence that the state withheld, because they do that a lot down here in Tennessee, showing that a school bus driver for the community of the elementary school was the one doing it to these kids. So that's a really big issue that he's got paperwork pending in the courts down there right now, and we'll see where that goes. There's another guy about how he was wrongfully incarcerated over evidence of drugs and guns found on other people's property that was next door, far away from where he was located, and wasn't even fingerprinted to him or nothing. And still, they used that type of evidence to convict him on, saying it was his when there was no backing up that such evidence. Several other cases as well I've seen, like you hear a lot of drive-by shootings, but they try to say it's not a drive-by, even though the evidence shows it to be drive-bys. People going to trials also with electrical things on their arms and gel shoes and everything underneath, so the jury can see they're incarcerated. But yet they don't do anything about these things. They think they can get away with everything. When you file your appeals, they try to negate from such appeals and say, oh, they have a right to do such when they don't. So, as it pertains to the rights of citizens under the 14th Amendment, there's a lot of these cases. We picked back up from where we left off last time I spoke with all of you. So, in the Congressional Act of that year I was speaking of in 1967, I believe, if you go and you look into the Tennessee Constitution on Article 11, Section 16, it talks about the Bill of Rights to remain inviolate. But if you read it carefully, it wasn't about the Bill of Rights in which people think it meant. It meant the Bill of Rights in which they've adopted into their Constitution, in which is actually changed from the Bill of Rights in which we have now today. So as the term shows under the Bill of Rights, the supportingness of the Bill of Rights, hold on one second. The supporting rights actually states that it's to be invalid. So because it's supposed to be remain invalid, if you go down to the schedule, so let me go ahead and read Section 16 to you. It says, the Declaration of Rights hereto prefixed is declared to be a part of the Constitution of this state and shall never be violated on any pretense whatever. And to guard against transgression of the high powers we have delegated, we declare that everything in the Bill of Rights contained is accepted out of the general powers of the government and shall forever remain invalid. And when you go down to Section 1, it says that no inconvenience may arise from a change of the Constitution in the schedule. So clearly showing that if you read the Bill of Rights, the Constitution of Tennessee, I'll read a little bit of it to you. They are as follows. You got the Section 3, which is establishment of state religion is banned and personal freedom of religion is inviolate. You've got test oaths, except if state or federal constitutions, as qualifications for office or jury are illegal. Sections 4 and 6. Universal suffrage is granted. Section 5. Unreasonable searches and seizures may not be carried out, Section 7, but they do it anyway down here. Bill of Attainders may not be issued, Section 8. Fair trial rights are granted and compelled self-incrimination is outlawed, Section 9, but they always break the right to fair trials. They don't want to let you use any previous trial transcripts or any kind of evidence. They object to everything that shows you to be actual innocence. And Also, let's go keep going. Double jeopardy and cruel and unusual punishment may not be practiced, section 10, 13, 16, and 32, but they do it all the time. And I've seen several cases where double jeopardy was attached, and yet they say, oh, no, and they try you again. Ex post facto laws are dangerous to free government and ban, section 11, but that's the main thing that they love doing is creating ex post facto laws and statutes. Habeas corpus must be respected unless the General Assembly declares otherwise during wartime, section 15. Evidently, habeas corpuses are not respected because, like recently in the podcast I heard of a man named Clarence Hayes that you did, his habeas corpus was never respected because the court in Hardeman County, Tennessee, clearly knew upon the evidence that they just railroading that in the case of Pierce, he was to grant his habeas corpus because he was brought first to the trial under a theory of being criminally responsible for the acts of who. There wasn't no one that acted. There was no one that was found guilty as a principal. So let's take that for instance. They're violating that habeas corpus statute in the Declaration of Rights in Section 15 of the Tennessee Constitution. We'll keep going. Freedom of the press is granted, Section 19. Well, that's kind of funny because one man's trial sat there and he had a reporter show up and the judge kicked her out of the courtroom before the hearing. Monopolies are illegal, Section 22, and I'll talk about that real quick. There's a guy, but I really don't want to get into the name of it, but he's the only guy evidently that creates laws named David Raven in Tennessee who helps create the criminal statute. But from my understanding, monopoly is where you can't just have one sole individual creating these laws, and from my understanding, he's the only one. So clearly, there's monopoly going on, and it's illegal in the state of Tennessee, further Section 22 of the Tennessee Constitution. And you got the freedom of assembly is granted, Section 23. Now, I don't know about y'all's freedom of assembly, but I do know one thing: if y'all assemble in certain areas in the county and stuff without paying, you're going to jail. Section 23 are being citated, so that was violated. In all cases, the military and subordinated to the civil authority, Section 24. Military law may only be levied against people in active militia or army services, Section 25. We're still reading going over the Bill of Rights real quick, so I'm almost done. Explicitly grants the right to bear arms, but the General Assembly may legislate against the wearing of arms in the interest of preventing crime, Section 26. Clearly, that they don't follow that one. There's too many deaths out there to prove it. Soldiers may not be quartered in private houses during peacetime, Section 27. Citizens cannot be forced to perform in the militia, see Article 8, so long as he will pay a suitable fine, Section 28. Orders of nobility or hereditary titles and rights are forbidden. Now notice that in Section 30, because orders of nobility means like Esquire beside attorneys' names and judges, but yet, hey, the titles, they're giving them the right to use it, but yet it clearly says it to be forbidden in Section 30. The state's boundaries are listed here in detail. Section 31, the state must provide for prisons and their upkeep. I'd love to see that actually happen, Section 32. Slavery is outlawed except as punishment for a crime, Section 33 and 34. I thought slavery should have been outlawed during the Civil War. Like it's supposed to have been, but once again, the Congressional Act clearly showed that they said they wasn't going to go by the 14th Amendment. So crime victims may expect certain rights from the state, Section 35, and subsections added by amendment in 1998. Sections 16 and 27, among others, are directly copied from the United States Constitution. So that's all it states in the Declaration of Rights, of the Bill of Rights, in Article 1 of the Tennessee Bill of Rights, and the provisions set forth in its Constitution, from my understanding, looking upon the Constitution of Tennessee from the Wikipedia Free Encyclopedia website. So if that's the only constitutional provisions, nowhere in the Constitution upon such will you see anything state that the 14th Amendment is to be followed. And of course, we all know the 14th Amendment was declared to be the rights for all, and I don't want to make anybody upset when I say these words, but it says slavery and those who were enslaved in the African-American community, it says they were to be prohibited slavery, but yet let's go over a little bit about the Constitution real quick. And the very first Constitution in Tennessee was created in 1796. And let me make sure it was 1796. Yeah, on June the 1st of 1796, concurrent with the state's admission to the Union, the second version of the Constitution was adopted in 1835. And a third was adopted in 1870 and is the one still in use today with subsequent amendments. So clearly the 1870 version of the Constitution is the one used in Tennessee, not the 1835. So the 1835 Constitution clearly made it straight to the point. It clearly says anti-slavery interests petitioned the convention to abolish slavery, a proposal that was rejected by the convention delegates. See, they're sitting there talking about the southern states. The Constitution that they adopted increased opportunities for citizens to engage in the political process, but it limited suffrage to white males. Similarly to other southern states such as Virginia, they disfranchised free black men who had the right to vote under the 1796 Constitution. This action followed fears raised in the 1831 Nat Turner Slave Rebellion. The second Constitution provided for a state Supreme Court to consist of 3 judges, with 1 judge from each grand division of the state. Judges were required to be at least 35 years old and would serve 12 years. Now, when it gets to the final 1870, when you read provisions of it, nowhere does the 1870 Constitution that Tennessee wanted to ratify and change and uphold that to this day state anything of acknowledging the 14th Amendment to be followed and the equal protection of rights of 42 U.S.C. 1981. Now, when you pull up 42 U.S.C. 1981, Equal Rights in the Law, I read Section 8 to all of you. It says, Statement of Equal Rights. All persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property as enjoyed by white citizens, and shall be subject to like punishment, pains, penalties, taxes, licenses, and exactions of every kind, and to no other. Now, clearly, the 14th Amendment made it clear that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of laws. Now, if the 14th Amendment is broken and breached in the rights to equal rights in the law, then it invokes the 42 U.S.C. 1983 civil actions for deprivation of rights, saying that every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory of the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action of law, suit in equity, or other proper proceeding for redress, except that in any action brought against the judicial officer or an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. For the purpose of this action, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia. So as everyone can see, judges and DAs can be sued, and they can be criminally charged for such things that they do down here in the state of Tennessee in their laws. They've created several statutes that go in violation against the Tennessee Constitution. Now, when you go back and what's just strange to me is when you read the Tennessee Constitution. I mean, I'm going to read a section real quick, and this is from Article 11, Section 8, which just ponders real quick that while reviewing it, it clearly says the following: that legislature shall have no power to suspend any general law for the benefit of any particular individual, nor to pass any law for the benefit of individuals inconsistent with the general laws of the land. So if they're not to pass any law for the benefit of individuals inconsistent with the general laws of the land, then why don't they adhere to the 14th Amendment in the federal Constitution of the United States? Because under Article 6, Section 2 of the United States Constitution, it says all judges are bound to uphold the supremacy clause of the land, because that's what's known as the supremacy clause. It's the supreme law of the land. So if they're to uphold it, and they swear out an oath to uphold and defend it and support it, then why are they not doing such? Why are they railroading individuals? Recently, they railroaded the man who did a supplement to his record. And to give evidence proving that the state withheld evidence that proved he didn't even live in the county, showing that he was lied on. And they denied him the right to give evidence, thinking that they could just get away with denying and just move along with his incarceration, but they failed to realize that's false imprisonment, and that they removed their oath of liability in their office when they did that. So I wonder what this guy's going to do after me and him speak and talk about filing suit against these judges and filing a complaint in the Board of Judicial Misconduct and other things. But when it comes to such things, if you really notice, this 14th Amendment is a serious issue down here in the southern states, especially Tennessee. Because under the 5th Amendment of the United States Constitution in Tennessee, it says one cannot be brought on by any accusations other than just by due process alone. They better have due process to be able to bring them to a trial, meaning they have to have due process to indict or a warrant. They got to follow the procedures of indicting someone. So if the law in Tennessee under Rule 6K2 clearly shows that you can call the record from the grand jury proceeding if you prove that a witness went before the grand jury as perjury, and when you prove such and that the state withheld, testimony from the trials out of the transcripts, and you prove that as well, how are you going to pull the record if the state of Tennessee district attorneys write you back in letters saying that they never have transcripts nor recordings of such nor minutes? So how is that possible? It seems like that when this guy argued his case, he clearly said, because from my understanding, the detective took the stand and said that he never went before a grand jury nor issued a warrant and didn't know why they were there. And, of course, the county moved all that out of the transcripts and no one see, but left a little portion and it's shown that it was missing. So when he argued these things, from my understanding, the judge wrote on the denial. They denied him the right to the grand jury transcripts or the minutes alone showing it even happened, because she clearly said nothing existed, showing that they are actually forging indictments in Tennessee, not going before a grand jury, and committing treason against every citizen, because from all three divisions this guy has, he has Middle, Eastern, and Western Division through other people's cases, sitting there talking about the grand jury proceedings are not recorded, they're not transcribed, and there's no minutes. Well, if that's the case, how come the law says it's supposed to be? It's clearly shown that somebody might be embezzling the United States corporation's money from the controller of the Treasury of the United States of America to hand down to every state's union a certain amount of money every year so people can be prosecuted for any alleged acts, crimes, or wrongs or acts. But what are they doing with the money? Because evidently I have seen several, and I'm not lying to you, I've seen several people's indictments rubber stamped with either an electronic signature that of somebody who's been dead for many years and yet sitting on an indictment many years later. And that's illegal as everything. So I just wanted to break down some things, and get to the bottom of this 14th Amendment and why the state of Tennessee doesn't want to adhere to it, why they don't want to follow it, why they want to lock people up wrongfully without evidence of the fact committed, with only testimony. And by the way, in Tennessee, it is very, very bad, and I'm not going to lie to anybody. It's really bad on people lying on people. They'll throw you in jail just over a lie, and then years later you prove the lie, and then they still want to keep you in jail. It's just awful. So like I said before, a long time ago, which is kind of I'm sure a lot of states say it, to those who have been done wrong, that don't come to Tennessee on vacation. You might leave lucky on probation. You might actually get a life sentence over someone lying on you, like recently hearing your podcast with Clarence Hayes. Hey, that man, he's wrongfully convicted. Reviewing his stuff. I mean, how can one be brought to the trial in violation of the supreme law of the land of the state of Tennessee and the Constitution? If Foreigner clearly said that they agreed with Pierce in the 1914 era, that's the case, by the way, Pierce first state, that certainly one cannot be found guilty of a theory of being criminally responsible without the acts of a principal being found guilty, then why did they even try him first? That was outside the due process clause of procedural due process. And the main thing is that when the prosecutors presented his case before a jury that found him guilty, they said that he hired a certain man's name to do the killing, but yet they dismissed it because they found out his alibi checked out. He wasn't there and he didn't do the shooting. So why is this man still sitting in prison 20 years later? So clearly showing that the state don't care. They don't investigate, like I said at the beginning. They only seek a conviction and they never seek true justice. For had they sought true justice, the overcrowding of the prisons in Tennessee would not be overcrowded. There would be plenty of space available for the wrong. So I would appreciate your time on all this, and if you want to speak anytime any further, y'all let me know. I have to go. All right. So thank y'all once again, and I hope y'all are able to look up things and try to get to you this Declaration of Rights from the Congressional Act soon.